Mayor.
Mr. Smith.
Yes, sir.
Just a few questions, and that was definitely a very thorough briefing. I'm curious about a couple things that you talked about. You know, at first blush, as you're kind of going through some of the statements that you did, there's a part of me that I guess can kind of see how people might get a little bit offended because you are using a few terms that just kind of catch people off guard. And I think you already know what those terms are or what those statements are. And I guess what I'm trying to understand first is the only place is as a taxpayer. Help me understand, does the law state that essentially you have to show some damage that is greater than that a taxpayer would have if hypothetically there was a damage to the taxpayers? But you mentioned, I think, I'm trying to remember.
Distinct injury.
Distinct injury, exactly.
Right.
So there has to be something that's distinct in what pool? Because obviously, for example...
To that person. So, Amir, if you were to file a lawsuit, there'd have to be some distinct injury to you, and it'd have to be a live controversy.
So let me give you an example. If I was a part of a class action against tobacco, I didn't necessarily have a distinct injury because there were a lot of folks that might have had, you know, said injury.
I presume you smoked or chewed, and that's why you were in the class action, so you would have a distinct injury.
Okay. So if that injury is based on where you live or the city in which, you know, you reside in, is that not...
No.
Okay. And I'm only asking because I really don't know, and obviously you've used some terminology that I just want to understand so that I can more clearly...
There has to be a controversy between the plaintiff and the city, between those parties. And that person who's complaining has to have some distinct injury to themselves, whether it's physical or mental or damage, whatever it might be. There's going to have to be something that's distinct to that person as opposed to injury that other people might claim. Because they're really third parties, because it's not like you and I being the party of a contract and having a dispute over it, and then some third party filing a lawsuit trying to set our contract aside. They're a third party. They don't have any interest in that particular contract. But in the context of what we have here, the interest is that of a citizen and a taxpayer, and I understand that. But there's a difference between having those types of interests and that of having legal standing. Let me let Amber add to that since she came.
That's right. I got to say something, right? One thing I'd like to point out that I think might help relieve some of the confusion. There are lots of lawsuits filed across the state by taxpayers against city where the taxpayers or the citizens do have standing. Here in this last motion before the trial court and the issues before the Court of Appeals, we are just dealing with the request for declaratory relief. It's a very special kind of cause of action that is governed by a special statute called the Uniform Declaratory Judgment Act. So it has its own special standard that's different from your general standard or from other statutes. And that's where we derive this language about a distinct injury to the plaintiff. Declaratory judgments are really special, and the statute narrows those down so that while we have open access to the courts, there aren't people in court all the time saying, we want a declaration about this, we want a declaration about that. The legislature made that a very special and narrow type of relief. So that's why we deal with this distinct injury issue, whereas there are other general lawsuits where a citizen who didn't have that special kind of injury might have standing.
Okay. Yeah, I'm just going to reiterate what I said at the beginning, which is I think it's pretty clear where the feathers were ruffled, and I think that knowledge hopefully will kind of help in the way we maybe address some of that stuff in the future. I mean, I think there are ways to say it without having to say someone is just blank. And I'm not trying to practice law because I have no idea.
Point well taken.
Okay, I just especially considering all things. You mentioned one other thing that has me a little bit curious, and I'm hoping that this question is in line. You mentioned the municipal building and how that's sort of an outdated reference. And with all the talk of charter and that sort of thing, I wonder whether or not there are any other outdated references in the charter from your perspective that you've also been able to identify. Again, this may not be the right time or place for that discussion, but clearly at some level, it'd probably be a good thing to identify where those names or issues that might be irrelevant today, so that we can avoid those sorts of concerns in the future.
You're right. This is probably not the good point to do that, but at some future date, we can do that.
Okay.
We've been focused on this lawsuit right here.
One last question about that municipal building discussion. And again, I don't practice law, so I apologize, because I've watched enough court TV to think I might
Hopefully
know
law and order.
Yeah. Municipal building, would the intent there have been the building in which the city does business? And I don't know, but I'm trying to understand, is the intent of the wording relevant, or does it become, hey, there's no longer a municipal building, so therefore the whole section is kind of irrelevant from that perspective?
I don't think anyone is able to discern what the intent was as far back as 1956.
Okay.
And in fact, Mr. Nichols, who is still alive and is at home, who is 93, I hope everybody saw National Geographic on the Kennedy assassination, because Mr. Nichols was on there when he went to interview Lee Harvey Oswald at the jail. Pretty interesting stuff. But I don't think we were able to ascertain that. But a municipal building can be any building that the city owns or controls or leases. And so, and any building where the city has that owns and leases where they conduct city activities is a place where they conduct business. So whether it's the city hall or I think the complaint was about the women's club, or but you can see the ridiculous of it, that if it was intended to be the municipal building at the time the city charter was enacted, that was the old city hall down on Beltline, I think, or maybe with Tyler, because that was later the municipal court. So you can see that's not what was intended.
Well, let me also amplify. In 1956, that was the only building. That was the police building, it was the fire building, it was the library. So under the circumstances, it was a different time, and that of course is why we wanted to get the definition clarified for the voters back in November of '07.
Okay.
Some of us weren't alive at that time.
Right. So I guess the only thing I've got left on that then is I would definitely be curious on the previous topic or previous point to know what those terms and or phrases that we have that are kind of outdated there, whether that's something that we end up tackling in the coming months, or if it's in the coming years. It'd probably be helpful to know where those holes are. So
Yes, sir.
thanks.
Mr. Mason.
Thank you, Pete, for a great job, I think, in trying to clarify a terribly difficult position. I can't help but think that throughout the city's tenure that we have always had executive sessions. I can't imagine personnel reviews and discussions about people coming into town, businesses coming into town, tipping our hand as to how we were trying to garner businesses coming into town. I can't imagine that we ever were without executive sessions from day one. And I think more than likely the fact that the charter didn't address that was an oversight from the very beginning. What do you think about that?
Well, I think the charter did address it, and I don't think that I don't think that that the charter was amended. I think it was just one other time, although there was an effort to it, and we just never got around to it. And the Open Meetings Act changed over a period of years, and so if that be the result, it's an unintended consequence of what the Open Meetings Act amendments did to the city charter. So I don't think it was an oversight. I don't think anybody recognized that there was an issue, and never had been raised before. But once it was raised, in abundance of caution, as I think John indicated, that the council stopped having closed meetings until after the charter was amended. So.
Well, yeah, I don't mean to say that anybody was at fault. It's just that I can't imagine running a city without some sort of a legal closed session. Is that even possible?
Well, yes, sir, I guess it is possible, but I'm not aware of any city in the Metroplex where they don't exercise it. They may not do it as frequently as Richardson or other cities, but to my knowledge, most of the cities in the Metroplex will have closed sessions when they're discussing litigation or obviously purchasing real estate, getting legal advice, and quite honestly, economic development is a very hot topic given the economic times right now, and you'll find that many city councils and economic development corporations are having closed meetings for that purpose.
And I would assume they always have had. Anyway, thank you.
Yes, sir.
Yeah, Mr. Smith, one question I have, and again, I appreciate your comments on this, is that one of the things that looks like we're relying a lot on is the concept of the moot doctrine. And could you go into a little bit more detail about that? Because I think it's important to have a good understanding of how this moot doctrine impacts this case from your opinion. Clearly, we had a charter election, but I really want a good understanding of that.
Well, I'm not sure how else I can explain it other than mootness is saying that there's no longer a controversy, and when the charter was amended, there's no longer a need for Mr. Gordon to say, court, don't order them not to have a closed meeting under the city charter. There's no need to have a declaration that they couldn't have a closed meeting because they can't have a closed meeting now. So moot means it is no longer a controversy. There's nothing that can be adjudicated. Nobody's rights can be affected thereby. And you have anything else to add?
Sure.
Go ahead, Amber.
The mootness doctrine is designed to only bring live controversies to court.
Okay.
So it has two parts. There's ripeness and mootness. When it's ripe, it's too early. It's not time yet to bring it to court.
Yeah.
And when it's moot, it's essentially too late, not in a statute of limitations type way, but just meaning that controversy doesn't exist. So if this type of relief had been requested in, say, 2006 before the charter amendment, then there probably wouldn't have been a mootness
Because
argument.
the charter had not been changed.
Right.
Okay. Well, and because I guess one of the reasons why I asked the question is you talked about the courts were not allowed or were not supposed to issue advisory rulings, and that's kind of where I was trying to go with this, is that if they did agree or they did agree with your argument on the mootness of this, then they couldn't really come out and say, well, you should or you shouldn't have had those meetings. Is that what you're trying to say?
That exactly, and you're a very fine attorney for recognizing that.
No, well, I just think it's important for you to be able to explain that to where everybody understands what you are trying to communicate here. Okay.
John.
Pete, I'm not going to ask you to speculate on what you think the outcome of this action is going to be, but I will ask you to speculate on two scenarios, basically. If we win and Mr. Gordon appeals, then goes back to the trial court, and is a trial likely to occur at that point in time? In other words, will the court allow this to go to trial or take it to trial?
That's one course of action the court would do, is have a trial on that issue.
Okay. And what are some of the other options that are?
Either side filing dispositive motions.
Okay. So then the other side of that, the other scenario is that Mr. Gordon wins, and then we appeal, and it goes back to the court. The results are basically the same, are they not?
If the city prevails,
Right.
then it's over with unless they appeal to the Texas Supreme Court.
Okay, to the Supreme Court.
Texas Supreme Court.
So the
And if the Texas Supreme Court declines to hear the case, it's final. Or they may decide to hear argument, and they may comment on it and say mighty fine, but we wanted to comment on it, which is sometimes they do. Or they may reverse it and send it back to the trial court or the Court of Appeals. Depends on what they find.
Okay. So you answered my question. This will not be one of these, do loops where it keeps going around and around. We're going to eventually have conclusion here one way or the other.
Yes, sir.
Okay, thank you.
Anyone else? All right.
Thank you, Mayor. Thank you, Mr. Kepper, for allowing us to make the presentation tonight.